Good morning and welcome to Assembly Judiciary Committee. We do not yet have enough to start as a subcommittee, so if we get a Republican member here, we will start as a subcommittee. All right, let's begin the committee, and again, we will begin as a subcommittee until we get a quorum. And the author we seem to have here is Senator Jackson.
Yes, sir.
Senator, you have a few items with us today.
Great. If we might start with the drug take-back bill, if that would be okay. That's
that would be
SB 1229.
SB 1229, right, which had been on consent, but we had talked about it and made amendments a little bit too late for consent. But
All righty.
let's start with that. Item number 15 then, SB 1229.
Thank you. Good morning, Mr. Chair and members of the committee. I'm delighted to be presenting SB 1229, a measure that I am jointly authoring with my Republican colleague, Senator Stone. And first, let me start by accepting the amendments that were proposed in the committee analysis. Leftover prescription and over-the-counter drugs, as we know, have become an increasing problem nationwide and certainly here in California. These excess drugs, often stored in medicine cabinets or under sinks for years, are increasingly being abused, creating a public health and safety risk. Without a means of disposal, many people are literally throwing old drugs in the trash or flushing them down the toilet, creating problems with soil and water quality because water treatment plants simply cannot remove pharmaceuticals from wastewater. One simple solution to this problem is having drug take-back bins in the pharmacies where we pick up our drugs, but pharmacies are concerned about potential liability and thus are reluctant to host these take-back bins. To eliminate this concern, SB 1229 would provide limited civil and criminal liability immunity to pharmacies hosting drug take-back bins if they meet a minimum standard of care. With that, I would respectfully ask for your aye vote, and with me to testify is Jason Smelzer on behalf of the California Product Stewardship Council.
Thank you. Your first witness, please.
He's actually stuck in security.
I'm told he's stuck in security.
Stuck in security.
Yes.
All right. Is there anyone else in support? Come forward, please.
Thank you. My name is John Dane, Executive Director, California Resource Recovery Association. We are in strong support of the legislation. Thank you.
Thank you.
Ed Behrens on behalf of the Los Angeles County Board of Supervisors in support of the bill.
Michelle Gibbons with the County Health Executives Association. We represent local health departments throughout the state in support.
Andrew Langley on behalf of the County of Riverside in support. Thank you.
I'm Kathy Rabin from the California State PTA Parent Teachers Association, and we stand in support of your bill.
Thank you. Anyone else in support? All right, seeing none, any opposition? Seeing none. Questions, comments from members? Senator, you may close.
Well, the best thing to do is keep quiet and just ask for an aye vote.
Thank you, and we'll take it up once we get a quorum. All right, your next item, item number 7, SB 1078.
Let's see, that is the arbitration bill. If we could go with the...
item number 10, SB 1336, the dependent children.
Great, that would be, I think, helpful while we wait for more members to appear. So I want to thank you for this opportunity to present SB 1336 today. This is a bill with the goal of improving efforts to identify and prioritize relatives for the placement of children in foster care. This whole arena is one that is in desperate need of reevaluation, reconstitution, recommitment, and certainly to try to address our neediest, most challenged youngsters. This measure has the intent of reducing the time that they spend in foster care and to help improve their chances of being reunified with their parents or reach permanency with a relative. This bill does this in two important ways. First, it would codify the family finding rule of court, which requires a dependency court judge to make a ruling of whether a county child welfare agency has exercised its due diligence in searching for known relatives when a child is removed from the custody of his or her family due to abuse or neglect. Secondly, it affirms how and when preferential consideration of relatives is considered by a county welfare agency in order to ensure that children in foster care are provided every opportunity of being placed with a relative caregiver when it is in their best interest. And as you know, when a child is removed from his or her home due to neglect or abuse, federal and state law makes it clear that the first preference, and all the studies and the data confirm that the first preference is to place children with a known relative, which thus increases their chances that they will be successfully either reunified with their parents and returned to their home, or if reunification is unsuccessful or inappropriate, placement with a relative will improve their ability to reach permanency. In an effort to achieve this goal, social workers are required to immediately begin conducting an investigation to identify and locate all adult relatives of the child, otherwise known as family finding. However, these practices vary by county, and many dependency judges apply different scrutiny in their evaluation of whether a child welfare agency has exercised that due diligence in their family finding efforts. Clarifying a uniform definition of how the courts may apply due diligence in family finding will help ensure that appropriate and effective steps are being taken to find and recruit relatives early in the dependency process. Regarding the affirmation of the relative preference consideration, this is a clarification that was recently reinforced in a fourth appellate ruling, which found that, quote, at least through the unification period, when a relative voluntarily comes forward at a time when a new placement is not required, the relative is entitled to the preference, and the court and the social worker are obligated to evaluate that relative. That was the finding in the fourth appellate court fairly recently, if I'm not mistaken. Regarding the concerns that are raised by the California Welfare Directors Association in SEIU, I am totally sympathetic to their concerns, the challenges that they have to do the best they can with sometimes very limited circumstances. I have met with them. I will continue to be working with them. I believe we are continuing that process close to some kind of resolution that recognizes this as a priority while also recognizing the realities of their somewhat limited resources. And I commit to continuing to work with them to develop mutually beneficial language that meets the goals of ensuring that relatives are not arbitrarily denied consideration while also balancing the county workload needs as well. So I thank you for your consideration. I have to be honest, the more I've dug into this issue, the more I realize that we really have a lot of work to do. This is just one step. I think it's an appropriate one. I think it's a reasonable one to try to achieve those goals so that these children can have the hope of a better life. With that, I would ask for your aye vote.
Thank you. First witness, please.
Good morning, honorable committee members, and thank you, Senator Jackson, for authoring this important legislation. My name is Yolanda Pineda, and I'm an attorney with the Children's Law Center of California. We represent about 32,000 children in foster care in Los Angeles, Sacramento, and Placer counties. I would just add that without some level of uniformity of what is considered due diligence, the identification and recruitment of relatives will continue to vary widely by county. Further, even when a relative does come forward, some counties are not considering their request for placement because of a misinterpretation of the current law. This legislation will help prevent children from languishing in foster care or congregate care when there are relatives willing to provide a safe and nurturing home for them. It would also ensure that the court and all parties in the case are informed when such a relative comes forward requesting placement. The relative assessment will not automatically result in a change in the child's placement. It will ensure that there is a careful consideration of whether or not it is in the best interest of the child. This legislation would ensure this process occurs statewide instead of being limited to the 2nd and 4th appellate districts. We are mindful of the opposition's concerns and hope to find common ground so we can help more children find permanent homes with their relatives. Thank you, and we urge you to support this bill.
Thank you. Next witness, please.
Mr. Chair and members, Lexi Howard with the Juvenile Court Judges of California in strong support of this bill, which seeks to address the urgent matter of children being removed and the requirement that family finding be done immediately, that local relatives and relatives at a distance be found, and that those be known to the court so the court can be involved in the due diligence process. Strongly urge your aye vote, and here to answer any questions.
Thank you. Anyone else in support?
Martha Matthews, Public Counsel Children's Rights Project, in support of the bill.
Thank you. Anyone else in support? Seeing none, is there any opposition?
Darn, they're not stuck in security. Just kidding.
Nice try. Thank you, Mr. Chair and members. Kathy Sunderling with the County Welfare Directors Association. I first want to start, we're opposed unless amended to the legislation, and I definitely want to start with the parts that we support and the approach that we do support, which is the relative placement preference that's in statute, both federal and state law, and is a best practice for our children in child welfare. We have more than 40% of our children placed with relatives, and it's very important that we do excellent family finding up front, and then also consider if a relative comes forward later in the process, if it is in the best interest of the child, to consider them for placement. We also are fine with the due diligence provisions that were talked about in the author's remarks. This is related to a rule of court that's actually just codifying what's in current law in the Welfare and Institutions Code for the county social worker to do that due diligence search up front. In fact, we think that the facts of the case that's referenced, the recent court case, suggest that if the court had done more oversight in that case, we wouldn't be at the point of arguing over the last issue, the issue that where we do have concerns and have our opposition to the bill, because we think that that would have been caught earlier, the assessment would have been done, and likely the child would have been placed with that relative who'd come forward very early in the process, not late in the process. The area of the bill that we have the continued concerns regarding is the part that requires whenever a relative comes in post-disposition before reunification is terminated, that we must in 100% of those cases do an assessment and consider them for placement. We believe that there are times when the circumstances of the case are such that it just won't make sense to consider a placement for that relative. We have offered a structure and had conversations with the senator related to the concept of having our social workers first think about the circumstances of the case, the situation that they're in, and then if they do not believe that it makes sense from a workload perspective, from a best interest of the child perspective, don't require them to go forward with the assessment and consider the relative for placement if there's no chance they're ever going to make that recommendation for placement, no matter how great the relative may be. And so what we've provided is amendments that would allow that social worker to make that first take, to think about the circumstances of the case, and then if it is not in the best interest of the child to move forward, tell the court that. Say to the court, the aunt just came in, this is late, the circumstances are such that in this situation, based on the placement, based on the reunification efforts that we're doing, the location of the relative, whatever it may be, tell the court, this is my reasoning. I'm not going to go forward with that assessment at this time. The court could then, in our proposed amendments, say, I overrule you. I don't agree with your reasoning. I think that that's not well thought out. I do want you to go ahead and assess the relative and consider them, and we would, of course, do so. We'd also give the parties to the case the opportunity to request a hearing and for that to occur as well as the relative in this case. And the court would be able, in our structure, to determine whether it made sense to provide the hearing if if the relative requested it, given that we're providing the reasoning to the court, and thus the court knows why we think we don't need to go forward. The concerns that we have, if the bill in print goes forward, you've got a situation where you're requiring all this extra work to really no good end. I think you're getting the hopes up of relatives who are never going to get that child for placement. It's going to just render our placements in a constant state of flux. I think the one area where we have some, I don't want to say impasse. I think last week we were at impasse. It sounds like the senator may be willing to consider this question of, at that upfront point, are you loading up that part of the code with a bunch of stuff that the social worker should take into account? Or are you saying, social worker, do your best diligence, consider the circumstances of the case, and then tell the court what you found? The latter is our strong preference. Once you start to put things into the code to say, but consider this and consider this, you end up essentially just doing an assessment, which is not what we're trying to do. We're trying to avoid that. So it'd be helpful to understand kind of where the senator's thinking is once folks have talked through that, so we could maybe talk a little bit more about that. But that's a really important thing for us. We don't want and we can't agree to a structure where that upfront assessment has a lot of essentially doing the assessment in it. That's what we're trying to get away from in the structure that we've proposed. I appreciate your indulgence for going a little beyond the time, but wanted to sort of think through that and explain to the members kind of where our thinking is and why we've put forward amendments that we think work within the structure that we've discussed with the senator, and hope that those amendments are accepted as we move forward in the conversation.
Thank you. Next witness, please.
Good morning. Tia Orr on behalf of the Service Employees International Union. We represent over 10,000 social workers across the state of California. I first would like to say, in concurrence with the senator's comments earlier, I think we're very close to a compromise. I think that we all have the same goal in mind. I think all of us are thinking about this in the best interest of the child, and there's no different from our social workers across the state that we want to always consider what's in the best interest of the child. I appreciate Senator Jackson's mention of workload for social workers and our inability in some cases to do everything that we would hope to do under existing funding. This bill is not keyed fiscal, so everything in this bill that social workers would have to do would have to be done under existing resources. We agree with the amendments that Ms. Senderling just described to you in the sense that the social workers in their experience and in their training have the ability to do a front-end assessment and determine whether or not it makes sense for a placement to move forward or for a full assessment of a placement to move forward. There are instances where a youth may be set to reunify with their parents in 2 weeks, and a family member comes forward and wants to take that youth in. In that case, does it make sense to do a full assessment when you have a child potentially going home to his mother or father in just 14 days? So in those instances, we want the social worker to have some discretion in whether or not to provide that full-on assessment with the agreement that the court would have the final say-so. And if the court disagrees with the social worker's perception or initial assessment or denial of an assessment, they can, of course, force the social worker to do that. We think that gets to the best interest of the child. We think that gets to making sure that all relatives are considered, and we think that strikes the balance between workload impact and, again, making sure that the number one priority is in the best interest of the child. I think we're very close to an agreement. I hope that we will get to one. I'm pretty confident that we'll get to one. Senator Jackson has always been a supporter of workers, and I know that she cares deeply for the children that we protect and serve. Thank you.
Thank you. Next witness, please.
Mr. Chair, members, Juliana Voris on behalf of the urban counties of California. Similar concerns to CWDA. We are concerned about ensuring that it's in the best interest of the child, and also we have significant workload and issues and fiscal issues with the bill, and therefore we are opposed. But we understand if it is worked out with CWDA, we would move our opposition. Thank you.
Thank you. Anyone else in opposition? All right, seeing none, I'll bring it back to the committee. Senator, I thank you for your work on this. And actually, as we've talked to proponents and opponents, I hear a lot of the same thing. So I think there is a possibility of reaching an agreement. I appreciate the work that my staff has done in a part of this conversation. And I'm hoping also that we can move this bill forward. I will see it again in Human Services, which is where it's referred to again. Right. So I have another opportunity to be a part of the conversation. This is something that matters a lot to me. So I do appreciate you bringing this forward. And I know Mr. Reif has been working this issue really for quite some time as well. And being mindful of workload and being mindful of the expertise and the concerns raised by the employees, I think we do need to make sure that we're setting up a situation where if a relative comes forward, that they are honestly being considered as a viable placement, and looking at the history of placements and the history of the relationship between that child and the relative as they move forward. Now, obviously, if we're just on the eve of a reunification, there are circumstances where it wouldn't make sense to go through all of the assessment that's essentially called out. But there should be an honest look at, is this going to make a difference for the child? Right. And sometimes when we get busy in courts and social workers and everybody, because there's lots of overlapping jurisdiction here, there are times when we do need to take a breath and see what's come forward and say, okay, what is in the best interest of the child, and be able to do that. And that's why I'm very much interested in this bill and want to see it move forward. So I appreciate you bringing it.
I concur completely. In fact, some of the suggested amendments I just heard were things that we had actually suggested earlier. So I think we're really close, and I think you framed the issue perfectly, because nobody respects the work that social workers do more than those of us who have been in the trenches watching them do almost the impossible with very limited resources. At the same time, we've got to make sure that there is that kind of requirement or structure, so that when you do have an opportunity for a placement, that again, the fact that social workers are overworked, they've got to recognize that they have to consider that, and if there is a good reason not to, potentially present that to the court. I mean, that's the kind of thing where we need to have some flexibility. The example of 2 weeks is obviously one of those situations. Nothing should be so inflexible that we end up defeating the purpose for why we're here. So I'm very confident that we are very, very close to an agreement. We're kind of all, I think, coming from the same place. If we can wordsmith this a little bit better so that everybody is equally pleased and displeased, we'll probably have reached the proper compromise, and I look forward to doing that.
Thank you. Yeah, I think the work that has been done to date deserves moving forward, and we're really talking about some semantics and a few of the details. So I think that's good. Any other questions, comments from committee members? Mr. Gallagher.
Yeah, I mean, it seems to me that the current conflict right now is, I think everybody agrees with the motivation of wanting to try and get these children with relatives who are suitable, that would be an ideal and preferential thing. But I think where the conflict arises is whether, how much discretion is with the social worker and the court. Because it seems like right now, the way the language reads, is like they will always have to consider a relative anytime they show up and say, I want to parent this child. Well, what if that child's already in a very stable foster care environment? I think I would want the court to be able to say, look, yeah, I know you're stepping up now, but you didn't a while back, and now this kid's in a really stable living situation, and so we're not going to do a full-blown assessment to consider you right now, because that doesn't make a whole lot of sense. I mean, so how much discretion do we give the court to decide whether or not to do a total reconsideration of the child's living placement? And I guess that'd be my question to you is, are you planning on drafting some language that would give more of that discretion, or do you want it to be considered no matter what? Well,
Considered versus a full assessment are two different issues. Certainly, the court should provide the guidance. And if a family member comes forward, for example, a quote-unquote late in the process, but we're still not it's more than 2 weeks away from a reunification. If the family member, again, remembering the priority is to try to get children in placement with a family member. We know that the results are unquestionably better when a child is placed with a family member. There may be instances where that family member isn't appropriate. If the family member steps up and says, petitions the court, for example, for consideration, then the social worker can come in and present to the court the reason that they don't feel that it's appropriate. Well, we're 2 weeks away from reunification, Your Honor. I think no court's going to change that. But You're right. It is a balance. How much responsibility do we put on the social worker for the ultimate decision, and how much do we put on the court? And the ultimate decision, in my opinion, belongs with the court, with the advice and discussion of the social worker, because that's the way the system is actually set up, is that the social worker does the research, does the investigation, and presents to the court why they believe a placement is or is not appropriate. And I think that that's a system that does work. The question is, to what extent now are we going to require social workers to bring that forward to a court when a family member comes up after a placement has been made? And that's where we're having the balancing right now, and I think we're very close. I think we'll get there, and I think we all agree that that is the sort of the structure. It's just how far do we go, and who gets the actual final say. I think it should be the court, with the input of the social worker. And the social worker can say, look, here are 3 good reasons why we don't think this is appropriate. The judge listens and says, I completely agree.
Would part of that discretion be whether or not there should be a full-blown assessment or not?
Yes.
Like, in other words, the court could go, well, I don't think we need to do a full-blown assessment at this time.
Absolutely. That's the court's decision.
That's your intent?
Yes.
And that's really the crux of the conversation here, is how much goes to the court, and how often, when are we taking it to the court versus some of the discretion for the social worker. For example, if we are just on the eve of a reunification, I think the social worker would probably say, hold off, why necessarily take it into court? I mean, that's a rare circumstance that I think you're going to get, a family member showing up right on the eve of a reunification, but it's illustrative, because that's a situation where I think the counties and social workers are asking for a little bit more discretion in what they move forward and how they do the full assessment of that potential family member. But I think on the other side of that, what we want to make sure through this bill is that whatever decisions are being made, and it's the social workers that have the day-to-day knowledge, and courts are seeing lots of cases and seeing it, making a decision based on the record and based on information that's before them. Are those decisions being made for that child? And what's in the best interest, really long-term, of that child? Are we headed for permanency? Are we headed for the reunification? Are we headed in that direction? If not, is this really a viable placement that maybe we wouldn't have considered a year ago, but now it is good? Yes, the child may be in a stable place, but is it the best place? That's the inquiry that ultimately happens here. And the crux of the conversation is ultimately the discretion to the social workers in the counties with respect to the work that needs to get done to prepare and put that into the court. And that's what I think we're actually very, very close on, because if you listen to the conversation, it's the same words. It's a lot of the same interest in moving this, but there's just some semantics and a little bit about what that discretion really is. And as we've talked, I hear everybody pretty much saying the same thing. I think we're on a fairly fine point. And to protect the ability of counties to do what they need to do, and especially the smaller counties who are workload impacted. Well, all counties are workload impacted, and need to protect that. And so that's a legitimate question.
Mr. Chair, sorry.
I was going to say, part of this is, people, every situation is a little different. I was just thinking, for example, you have someone who lives out of state. And, the inclination is you want to keep them here closer to their parents. But let's say they live out of state and they have 3 children of their own who are doing beautifully well. They're a solid family that will love and care for this child. They've got grandma at home, with no disrespect to grandmas. I'm one myself. I don't want to disparage grandmas. But grandma's having a little trouble trying to keep grandchild and maintain the kind of appropriateness that this child needs to flourish. The family member comes in from out of state and says, look, I know we're out of state, but we have a safe, secure, happy home that we can offer. Then the next question is, look, we found a placement. The child's been there for 2 years. Grandma loves this child, but we grant that there are problems. But we don't want to upset the apple cart. This bill, and trying to work with them, would give some discretion to the court to decide whether or not they want an assessment or not. It frankly takes a little bit of the burden off of the social worker, but also requires a little more time by the social worker to come in and say why they don't believe that this is appropriate, why they don't want to do a full assessment. But I think it also protects the child. And that's where we're trying to get, because as I said, every situation has its own nuances. They're all different.
If I might add on, Mr. Chair, for a moment, just thinking through.
I'm going to.
Okay.
Unless somebody asks a question.
Okay.
Other questions or comments from the committee? We don't have a quorum just yet, so we're stacking up. All right, Senator, you may close that bill.
I think this is an important issue. I appreciate the discussion. I appreciate the concerns of the people who are responsible for these children and also the courts, which also have responsibility. These are our future. These are our resources, our children. They're really the most important thing that we can offer, and it's my hope to come to a resolution that's in their best interest. And with that, I would ask for your aye vote.
Thank you. We do have a quorum. Would you just call the roll, please?
Stone?
Here.
Wagner?
Here.
Alejo, Chow, Chu?
Here.
Gallagher?
Here.
Garcia?
Here.
Holden?
Here.
Mainshine, Ting.
We do have a quorum, so I will take a motion. The motion on this bill is due pass to Human Services. Second. Do you have a motion and a second? Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo, Chow, Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia?
Aye.
Garcia, aye. Holden? Holden, aye. Mainshine, Ting.